can't do that anymore. Okay, let's start from the beginning. Mark is going to use this thing here, and I'm going to have to give you a very short lecture of what is international law. Now, the difficulty is that it's not properly defined anywhere, but the purpose of this talk is the legal aspects, and I stress the legal and not the political, and not the social, and not the economic problems of the Arab-Israeli conflict. I'm looking solely at the legal aspects. Now, when we start to look at that, I have to look at international law, and one of the things that's important to recognize that it is not coextensive with morality, or is it with a particular public opinion. International law, in contrast to domestic law, international law is quite nebulous because there's no sovereign. There is no body capable of enforcing the law, except very indirectly. The United Nations, sort of, but we've seen what's happening in Syria, there's no enforcement. So, unlike a nation-state, international law is a lot of public pressure, political pressure, and there are certain norms called, where customary rules of behavior are accepted by states because they feel obliged, as a matter of comity, to obey these laws. Because if they don't obey it, then we'll find other states will treat them in a disrespectful manner, and if a position comes where both states have to act in a reciprocal manner, they will find their frustration. So we find states who will obey customary law because they feel they have to. And one of those customary laws is the Hague Regulations, dealing with the manner in which war may be carried out and the manner in which prisoners and civilians should be treated. Now, I'm not going to go into any of that, but that's a whole corpus of jurisprudence and takes at least 7 or 8 lectures. Now, apart from customary rules of law, there are voluntary agreements that are made between sovereign nation states. And I stress the sovereign nation states because there is a process whereby a nation state can sue another nation state if both agree to return to the jurisdiction of the International Court of Justice. Now, these agreements are sometimes bilateral, in which case they're called treaties, and if they're multilateral, like the United Nations, Charter, the United Nations Charter or the conventions, they are multilateral, but they all depend upon reciprocity. And the difficulty is that when you have non-nation states who are starting to act as nations, like the PLO, they claim to be able to enforce or to be recognized as being subject of these international treaties, but they are not. The PLO purports or claims the right to be protected. I suppose individuals claim to be a right protected, but individuals have no rights under these treaties. It is states that have rights. If a state wants to take up the case of an individual, one of its citizens, and on behalf of that citizen, then it can do so. But the citizen normally doesn't have a right of action against another state. So it's very important to distinguish between where states are involved with one another and non-state entities like the Palestinian Authority. Palestinian Authority is not a state, although there is some degree of recognition in the United Nations of that. But we have to be clear about that situation. Okay, we have agreements. Now, the UN Charter. The UN Charter has 2 major sections, or 2 major parts. One is the Part 7, in which decisions are taken by the Security Council, which, if taken properly, have to be performed and enforced by the nation states. And one of those is if sanctions have to be imposed, as they had against Iran, or sanctions have to be imposed against Syria. If it's taken under Chapter 7, then they are enforceable. Next point. UN resolutions taken under Chapter 6 are only recommendations, and they do not have to be obeyed necessarily. It's a question of political choice by the various nation states. Now, as I said, recommendations are not law. Now, one of the important things, and I haven't put this up, is that it's very important that if a United Nations institution determines that a certain action is illegal, that is not a determinate decision. The fact that a non-juridical body declares something to be illegal is purely political. I can go declare what you've just done to me is illegal. It certainly is. It is not a final determination. Whether a thing is legal or otherwise has to be determined by a judicial body. That is a body that has been properly trained, the bench is independent, and it gives its reasons based upon international and other law for coming to its decision. So the determination by the Security Council that Israel's annexation is illegal is not a question of law, it is a question of policy. Similarly, the settlements claimed to be illegal are not determinations of law, they are positions of policy. The International Court of Justice, and we'll come to that in a second, please next one. The opinions of the International Court of Justice have two strings to them. First of all, those dealing with a controversial issue, there is no jurisdiction in the International Court of Justice to make a decision unless the parties, all the parties involved, agree to a term, that is, agree to submit themselves to the jurisdiction of the International Court. And the reason for that is that states are sovereign. There is nobody above a state except political opinion, unless a state concedes at the very beginning that it will submit and accept the decision determined by some outside body. Consequently, where you have a controversial issue, the ICJ, if the parties agree, can issue a decision, and that is binding in international law on the parties. In the case of the advisory opinions, only members or institutions of the United Nations can request an advisory opinion, and those opinions are not binding. However, they are advisory in the sense that nation states that have sought the opinion or have received it can choose either to accept or to reject that opinion as affecting their particular policy. But they are not binding. The only UN resolutions which are binding are those passed by the Security Council under Chapter 7. And they are, in the sense, executive decisions. Next, please. Oh, there's one other point I've forgotten here. When we look at some of these decisions, particularly the decision, or the opinion, I should say, on the fence, you have to read it within a political context. Because the formulation of the question which the court is asked to opine upon will determine the sort of answer. The General Assembly, or the Security Council, when it frames its question, frames it in such a way that it frequently will ask the court, are we right in making these assumptions that we have made? In other words, they will set the opinion, they will set the terms of reference in such a way that the court will generally affirm or will take as a given the terms of reference, the basic points. And if we take the case of offence in the preamble to the decision or to the resolution asking for the case to be heard, the resolution contains at least 5 or 6 provisions in the preamble which state that Israel has acted illegally. Israel has acted actions as a stumbling block to peace negotiations. These findings of fact or law determine essentially the way in which the court is going to frame its response. And so an advisory opinion is a political opinion. It is not a legally binding opinion. Next, please. Okay, one of these claims. Right, the Arabs claim Israel's existence is not justified at all. Why? Because it was founded upon a Balfour Declaration. It was founded upon the mandate, and the British and the French had no rights to institute mandates. You were deprived us from our right of self-determination, and this is our land. You brought in all these foreigners from Eastern Europe, and they are inimical to our self-determination, and Israel has no justification. However, even if it does, then we Arabs have the same rights as the Palestinians, and since we were turfed out of our land by Israel's 1948 revolution against the mandatory government, we have a right for our refugees to return. That basically is the thrust of the Arab argument, that the Jews in Palestine are essentially a foreign body, and they shouldn't be there at all. They do, of course, unfortunately or fortunately, forget that virtually half the population of Israel is from the Middle East, that they are Jews from the Arab countries who were persuaded to leave or were expelled from their homes there. But essentially, the Arab position is that you shouldn't be here in the first place. But even if you are here in the first place now, then we have equality of rights, and we feel that these rights are being trampled upon by the Israelis. If we talk about the West Bank, which is the area that is really in dispute now, the West Bank was Arab, is Arab, and should have remained Arab. It was captured as a result of it was taken under Jordanian jurisdiction and was annexed by Jordan. And since Jordan at the time of the annexation also was a member of the United Nations and had already signed up to the Geneva Convention, therefore the Geneva Convention applies, and the Geneva Convention states under Article 49, paragraph 6, that an occupying power may not transfer or you would take people out and expel. Well, it's not exactly expel, but deport, that's it. Transfer or deport the population of the occupying power into the occupied territory. So I'm going to come to that later, but this is their position, and consequently the Arabs' claim is that with the application of the Geneva Convention, Article 49.6, Israel's encouragement of the settlement of the West Bank by Jews contravenes that provision. Okay, let's go on, please. Now, the Jewish position is somewhat different. First of all, the argument is that the Jews are not newcomers. There's been an unbroken historical, demographic, religious, and cultural connection with Palestine. And I've just said that 50% of the present population, even before that, 1948, came from the Arab states. Juridically, after the Ottoman defeat, Palestine, Syria, and Iraq were not annexed, but were set under a mandate. Now, this is where I'm starting to get into the legal jungle here, because it's important to recognize what the mandate was. Under international law, that is, customary international law, at the end of a war, the victor was entitled to annex the captured property. Now, there's no doubt about that. If you captured property and you were the victor, you could do what you liked with it, and you could replace its government. If there was a peace treaty, well and good, you gave back some of the land, perhaps, but perhaps not. In the case of the First World War, President Wilson, United States President at the time, had different concepts. And because the Americans purported to have saved Britain and France from what would have been certain defeat in World War I, both Britain and France were compelled to accept Wilsonian concepts of self-determination. By the way, the president was an academic professor of history and political science and knew very little about war. And Wilson said, look, colonialism is out. We're not going to have any more imperial expansion. It is true that you won the war, but you wouldn't have won it without our assistance. Therefore, if you control property, you are to control that land for the benefit of, generally, the indigenous people. That was the concept under the mandate, that certain states were approaching statehood could only become states if they received tutelage by the more, quotes, advanced nations. That was the case of Syria, that was the case of Iraq, it was the case of Egypt, in a sense. It was not the case of Palestine. And we have to be very clear about that. Palestine was a completely different mandate. And the purpose of the Palestine mandate was premised upon the Balfour Declaration. I want to come to that in a second. Can we, if you read that, fine. Oh, this is just a map showing where the Jews were not colonial, but before the Arab, but that they controlled or they were settled in the whole of this area. So it's much beyond the area of Israel now. So they're not a foreign body, unlike other colonial powers, like France, like Belgium, like Britain, who went into countries where the indigenous population was relatively unsophisticated, I'll put it that way, and took over and excluded and even obliterated them. This was not the case in Palestine or in Israel. There's always been a strong Jewish presence, and to the extent that the Jews did come in the 1890s to 1920, and even afterwards, they did not take over the land, as it were, but at least they purported to buy. Now, there's a big difference between taking the land and buying the land. The fact that, unfortunately, those who occupied the land had to be removed or had to be displaced presents some problems which even today Israel has some difficulty in resolving. Next, please. Okay, now before the 1914-18, before the conclusion of the war, the Arabs expected that Palestine, that the whole of the Middle East would be an Arab state. And that started in the McMahon-Hussein correspondence, and the Arab claim is that the British promised the land up to the Mediterranean would be included in an Arab state. That is not the case. If you read the letters as I have done, there is certainly a lot of ambiguity, and there's no way in which you can say an agreement was concluded. In fact, King Hussein, or the king of the Hejaz, states in his last letter that he doesn't want to insist upon expanding up to the Mediterranean at this present stage because he doesn't want to upset the relations between France and Britain. Because Britain at the time when it was discussing this with Hussein said we have other commitments which we can't break. And those commitments in fact dealt really with the promises to France which were in the Sykes-Picot Agreement. Now that agreement again is not a legal document in the sense that it was never publicized and was never given a recognition, but that was the deal between France and Britain that was concocted as how they were going to carve up the Ottoman Empire when it was going to be dismembered at the end of the war. The Balfour Declaration, again, a statement of British policy designed to induce, I think, the Jews in America to put pressure on the president to come into the war because Britain and France were losing it at that time, and they hoped that the Jewish influence was sufficiently great that their pressure would induce America to act and come in on the side of the Allies. I should say that the Germans had a similar idea and had also prepared a declaration, and they had intended to do exactly the same and to address it to the Americans, asking them to come on the German side. The Brits got there first. And finally, just before the conclusion of the discussions in Versailles in 1918, Faisal, who was the number 2 son of the King of Hijaz, and Weizmann, who was the head of the Jewish Agency at the time, had an agreement on cooperation, that they would get together and work together. However, it was dependent upon Faisal being accepted as the ruler of Syria. And in the bottom of this agreement it says, I only agree to do this provided our arrangement and my declaration is accepted. And we'll see, of course, that the French chucked out Faisal, and so this agreement didn't stand. Next, please. Okay. Well, I've already dealt with that. Now, under the League of Nations, which was constructed or established as part of the Treaty of Versailles in 1920, President Wilson was able to have injected into it or inserted into this concept of a mandate. I want to spend just a few minutes on what that means. Normally, as I said, a victorious country will take over and annex the territory of the captured, the territory of the vanquished state. In this case, the mandate restrained them. A victorious state agreed to take administration of the captured territory. It did not exercise sovereignty. It administered it in accordance with the terms of the particular trust. Now, a mandate is essentially a trust. There is a set law in the trust, that is the person who establishes the trust. In this case, you might say it might have been the Ottoman Empire. There's the trust property, which in this case is Palestine. There's the beneficiary, which in the case of Palestine is very clearly the object of the Palestine Mandate was the establishment in Palestine of a Jewish homeland, and there are other provisions in the Palestine Mandate which show clearly that the Jews, as a people, were the beneficiaries under that trust. The League of Nations sort of acts as a supervisor of trusts in the same way that the administration of trusts here are administered by a government department, and if a trustee acts improperly, then there's control exercised by the government. So in the same way, the League of Nations purports to act and supervise the activities of the trustee. And the trustee in the case of Syria was France. In the case of Palestine and Iraq was Britain. And there are instances where Britain, particularly 1939, was castigated for having breached its trust provisions when it stopped the immigration and the settlement of Jews in Palestine in 1939. But that's something different. But the point I want to make is that a trust continues to exist even if the trustee himself drops dead or surrenders the trust. And I'll show you later that that is very important in this particular argument, because the mandate, it can be argued that the mandate continues to apply to such land as was not properly appropriated in law. Now, that means that the West Bank, and we'll see this later, the West Bank was not appropriated legally by Jordan in 1948, and the sovereignty between the years 1920 and 1948, the sovereignty was held in abeyance, sitting up in the sky, until in 1948 Israel, by its act of or Declaration of Independence, crystallized the sovereignty on that part of Palestine over which it exercised control. And we'll see that Jordan did not have the same rights. Okay, next one, please. So there we have, these are the League of Nations mandates. territory to be administered politically by advanced nations, sovereignty in abeyance, and mandates were different according to the character of the population, physical size, and proximity to advanced nations. Next one, please. Now, this becomes important because there is an advisory opinion of the International Court of Justice which dealt with the case of South Africa against Namibia in 1950 and in 1962, I think. I may be wrong with the date. But the court said unequivocally that the mandates survived the closure or the dissolution of the League of Nations. A League of Nations mandate, or the mandate still prevails. And we will see under Article 8 of the United Nations Charter that until trustee agreements are settled in respect of mandated territories, the rights of peoples under a mandate shall not be prejudiced. And that becomes very, very important when we're discussing the West Bank after 1967. So the point to keep in mind here is the mandate itself is a legal instrument, an international legal instrument which was recognized and does not terminate just because the trustee has thrown up his hands and said, I can't administer this trust any longer. A trust continues to subsist after the death of the trustee or the trustee's surrender of rights, and it continues until the beneficiary is able to come of, quote, age, which in the case of the mandate means that the state or the people have reached a state of political maturity when they can declare independence and operate as a state and be recognized. And that's the point, to be recognized as a state. How am I doing for time?
Yes.
Okay. Now, Palestine mandate. I want to contrast the Palestine mandate with the South African mandate for a reason. In the International Court of Justice opinion, they look at the historical basis, very briefly, for the establishment of Israel, and they look, first of all, in one sentence to the Palestine mandate, in paragraph 70. They look at Palestine mandate, and they say it still exists, yes. Israel was established as a result of that partially, and then they state that the mandate still subsists after the dissolution of the League of Nations, and they say the purpose of the mandate was to advance the self-determination of the people, of the indigenous people. Now that is wrong in the case of Palestine. They were examining the mandate for South Africa, in the case of British South Africa, which is now Namibia, and that is a very, very simple mandate. It merely says the mandatory has to stop, engage, not to supply weapons. The purpose of the mandate is to advance the indigenous people, and there's to be no slavery, and, oh yeah, very important, it has to be temperate, no drink. That, and I have an article here if anybody's interested on the court case, but the mandate which the International Court of Justice used to determine or to make the determination that the purpose of mandates was the self-determination of the indigenous people is completely and utterly wrong in the case of Palestine. In the case of Palestine, completely different. Can we go up a bit? Oh, sorry, we've got the purpose is to recognize internationally the Jewish historical spiritual connection with Palestine, to establish a Jewish homeland in accordance with the terms of the Alpha Declaration. And why was it called a Jewish homeland? Because at the time, the population, the Jewish population, was dispersed throughout Europe and dispersed throughout the Middle East. And so all you could say was a Jewish homeland, and there is a lot of declarations in Parliament saying that ultimately, the establishment of the Jewish state would depend upon the ability of the Jews to get themselves together and to invest appropriately in their homeland. And here, the powers anticipated that if and when the Jewish immigration became majority of population plus the capital, then in all probability a state could be established, but a state only becomes established if it's recognized by other nations. And that would depend upon those other nations taking the step. Now, so far we haven't got anywhere except beyond discussing the legal background. The San Remo resolutions were in fact resolutions that were passed by the powers, the Allied powers, after Versailles. San Remo was a continuation of the Versailles negotiations, and essentially it dealt with the disposition of the Ottoman Empire and the allocation of its territories amongst the victorious allies, all in accordance with mandates. And in particular, what I've taken out is the Treaty of Sèvres, which follows the San Remo resolutions. In fact, was a political disposition of these territories, and it was crystallized later in what was called the Treaty of Sèvres in 1920. I'm not sure if the next one. This is, I think, I'm not sure. Anyhow, it doesn't matter, it comes to the same ground. The Treaty of Sèvres was agreed to between Turkey and the Allied powers, in which Palestine was going to be held under the British mandate in accordance with the Balfour Declaration, and it was actually quoted word for word from the Balfour Declaration. And Syria was to be governed or administered by France, and Iraq, or called Mesopotamia, was governed by Britain. Egypt was under sort of viceroyship and had been ever since about the 1880s under Britain, and the King of Hejaz was given jurisdiction, or took jurisdiction over Saudi Arabia. He was, of course, kicked out two years later by the Saudis. But that's another story. The important thing is that Turkey undertook, by the provisions of the Article 132 of the Treaty of Sèvres, to cease all connection with the territories outside the core territory, the core boundary of Turkey itself. All the Ottoman possessions Turkey was relieved of all its Ottoman possessions except its core state. Next, please. Well, here's the treaty. Okay. Now, the Treaty of Sèvres, while it was agreed by the government, was not ratified by the parliament because you had a civil war in Turkey, and the objection was the way in which the European properties or European territories were being disposed, primarily the Balkans and Greece. And so Ataturk was the leader, led a revolt, and it resulted in a delay on the implementation of the Treaty of Sèvres, and it was only with the Treaty of Lausanne that the factual situation was recognized. Now, it's a bit difficult to understand this. What happened was that Ataturk managed to have the terms of the peace agreement between the Allied powers and the Ottomans changed such that the Balkans were dealt with separately. But in the interim between 1920 and 1922, the mandates had already been issued. So if you look at the Treaty of Lausanne, it doesn't deal with Palestine at all because Turkey doesn't have a common border with Palestine. It has a common border with Syria, and it has a common border with Iraq. Consequently, you have to read the Treaty of Lausanne very carefully, but we do see in a provision that Turkey surrenders all rights over its lands and all rights over its citizens outside the boundaries of the kernel or the central part of Turkey. So this is the basis upon which the mandate was issued. Next, please. Right. Now, the Palestine mandate. This is very different from any other mandate. I've looked at the mandates of Syria. I've looked at the mandate. Iraq never had a draft mandate. It was never consummated. Instead, an agreement was settled. I've looked at the mandates of South Africa and the other mandates, and they are completely and utterly different. It's like chalk and cheese. This mandate is very, very specific. First of all, it deals with, the preamble here says that the mandate is responsible for putting into effect the Balfour Declaration for the national home for the Jewish people, provided that it doesn't prejudice the civil and religious rights of existing non-Jewish communities. No, it doesn't mention Arabs, it doesn't mention Islam. It mentions non-Jewish. Now, communities, in this sense, is another word for the millet. The millet system was the religious communities which the Ottoman government recognized and gave a certain amount of self-determination powers. They could govern themselves, they could tax themselves, but they were still subject to the Ottoman rule. So we're talking about essentially non-Jewish religious groups. It doesn't mean national groups, and that's the important thing to note. And it's given, first of all, the historical connection to the Jewish people is recognized internationally, and it's the basis for reconstitution of national home. Now, the first article, very important. The mandate had full powers of legislation and of administration. The draft mandate that was submitted to the League of Nations stated that the mandate would have sovereign powers of legislation and administration. That was deleted. And we know from speeches by Balfour and by Curzon and by others that sovereignty did not reside in the mandatory. Sovereignty didn't reside in the League of Nations either. It's not capable of exercising power. Where did sovereignty arise then? It certainly didn't remain in the Allied powers. Again, they're not capable. And the conclusion is, and I've researched this extensively, at least 7 or 8 legal scholars come to the conclusion that sovereignty was held in abeyance and sitting there until the beneficiary came of, quotes, of age, or arrived at a situation where it was under political conditions that it could govern itself. Article 2. The mandate is responsible for placing the country under such political, administrative conditions as will secure the establishment of the Jewish national home. The word political does not appear in Article 1, and it doesn't appear in Article 2.2. What rights do the non-Jews have? They have their civil and religious rights, which means that there may be, in the future, a political structure in which the Jews have control, but they cannot act in such a way as to deprive non-Jews of certain rights, civil and religious rights. And it's supposed to have local autonomy, and the Zionist organization is going to be one of the agencies. Next one, please. Okay, now, Articles 6 and 7, absolutely crucial. The administration of Palestine has an obligation to facilitate Jewish immigration and shall encourage settlement by Jews on the land of Palestine, including state lands and wastelands. So it's not just state and wastelands that there's a right for the Jews to settle, it is the land contained within the boundaries of Palestine. Second, Article 7, again, response for enacting a nationality law and to facilitate Jews to acquire Palestinian nationality. So there is clearly an attempt here to focus the powers of the administration so as to enable the Jews ultimately to set up their own state, based upon not conquest, not their own conquest, but based upon the mandatory power that was entrusted and given to them under the League of Nations. Remember, the rights originally of the conqueror were to annex conquered land. Wilson was able to persuade Britain and France to restrain themselves and not to exercise that power of annexation, but to hold the land in trust for the purposes set out in the various mandates. And the mandate in the case of Iraq and Syria was for the local people to have sovereignty, but that was not the case in the case of Palestine. The case of Palestine was to encourage the ingathering of the Jewish people from Europe or from the Arab lands, and ultimately to set up a state. And there are plenty of statements in the House of Parliament and in the House of Commons in which that was the purpose. Next, please. 10 minutes to go. Wow. Okay. Right. Land system appropriate for the needs of the country. Restrictions, no territory to be ceded or leased to the control of the government of any foreign power. Question mark. What happens to Transjordan? Transjordan was part and parcel of the Palestine Mandate, and the administration of that was given over to Abdullah, and Britain gave independence to Abdullah, to Transjordan, in 1946. Was that a breach of the mandate? Could be. I think so. But let's make it on to it. Next, please. Move fast. Okay, Article 25 of the mandate. Now, the mandatory was empowered to postpone or withhold the application of certain provisions of the mandate to the territory east of the Jordan. And they did so in the case of Transjordan, and Jews were prohibited from migrating there. I should say that the chief political officer at the time, I've forgotten his name unfortunately, made the statement. He says the intention of Transjordan in 1920 was it would become an Arab state, and that the Arabs in the west of the Jordan River would be transported or transferred to the east of the Jordan River. That was the intention. There was going to be a population not exchanged because there were no Jews east of the Jordan River, but the Arabs, it was intended to transfer the Arabs to the east. It didn't work out, but that was certainly the purpose behind the establishment of Transjordan. But there are two other reasons as well. It was too expensive for Britain to administer Transjordan, and since Faisal, who was supposed to be the king of Syria, was kicked out by the French, Britain had to save his face, and so they put him as king of Syria, king of Iraq. And of course Abdullah got very upset because he was supposed to be the king of Iraq, and so Abdullah brought an army up from Hijaz and got as far as a town called Man in east of the Jordan River, where he was met. Kirkbride, that's the guy's name. Thank you. Kirkbride met him with a group of 50 policemen. They all sat down and had a chinwag, and Kirkbride persuaded Abdullah to take administration, to take over administration of Transjordan Jordan on behalf of Britain, and not to try to beat the French, because that would create problems between France and Britain. So Abdullah, in a sense, was Britain's agent for the administration of Transjordan. But Kirkbride is quite clear in his book, Something of Thorns, I can't remember the title, where he says the purpose was to transfer the Arab population to east of the Jordan River, and that Abdullah was given this second-rate jurisdiction to satisfy, to save his face, because his brother had taken over Iraq, having been kicked out of Syria. Next, please. I'm digressing. Okay, now we jump right to the United Nations. I should say between 1920 and 1940, 45, 46, there were Arab riots against Jewish immigration. There were the riots of 1920, which incidentally, the Hajjamin Husseini was encouraged by the British administration, by one Colonel Walters Tyler, to start a rebellion against the mandate. In 1920, when the first riots broke out, that was coincidental, it was contemporaneous with the debate going on in San Remo about the mandate. So the riots were instigated initially by certain British officers, and subsequently Hajjamin Husseini took up the reins and continued to incite the Arabs against any Jewish settlement in 1920, 1929, to 1936 to 1939. Anyhow, we had the Second World War coming in and intervening, and I'm not going to deal with that. Can I go straight to the United Nations? How's the time? Oh, right. Purpose of the United Nations: to develop friendly relations among them based upon the principle of equal rights and self-determination of peoples. I stress this because there is no right of self-determination. There is a desire to achieve self-determination. You develop friendly relations based upon these principles. But there is no right, legal right of self-determination. That's the point I want to get across here. The fact that the General Assembly has passed resolutions saying rights of self-determination does not make it so. What does make a right of self-determination are the covenants, the human rights covenants. Now the question is, can they be made to apply in the situation of the West Bank? And I'll leave that for a second. Next, please. Okay. Members are supposed to refrain from use of force against the territorial integrity and independence of any state. I emphasize the word state. Not territory under dispute, but a state. And the UN is not supposed to intervene in matters which are internal to a state, except unless that is likely to cause international conflict. Next. As opposed to that, you have Article 51. And I don't want to get into that one because that is really the basis of the fence. Again, it's an inherent right. Now, the word inherent presupposes there's some other right outside the UN Charter. And there is such a right. That is the right of preemption, which is based on customary international law, where there is where a country or a state is under immediate threat and there's nothing that can be done to prevent that threat taking place except by immediate action which is unavoidable and militarily necessary. That is an inherent right of self-defense. And that right arises only if it cannot be otherwise avoided by the use of force. I don't know if this has come across clearly, but I'm a bit confused here. The inherent right is something that can be used when there's no other choice, and the only choice is one of military force. Now, this is what happened in the case of the alleged, Israel alleges happened in the case of the 1967 war. It certainly happened in the 1973 war. And the difference is important, because if a victor captures territory as a result of a defensive war, as opposed to an aggressive war, there is no obligation on the victor to return that territory except and until there is a peace treaty. That's very important. So we start here that if Israel, and I think there's a lot of evidence to show both in 67 and 73, certainly in 73, that was the defensive war, and until there is some agreement, there is no obligation for Israel to return the territory. If they want to make an agreement on it, it's a different question. So far, we don't have an agreement. Next, please. Okay. Now, the argument that Israel has a right to be in the West Bank and the right to settle is not determined by, in my opinion, by the Geneva Convention, sub-article 49.6. I'm going to digress a bit to 49.6. 49.6 says the occupying power may not transport or move its population, the occupying power's population, into the occupied territory. There may be an argument that Israel is in breach of 49.6, that by allowing Jewish settlers to go in and not taking positive action to prevent them, I don't see it, but let's assume that it's right. My argument is a different one. Article 8 of the UN Charter gives Jews the right to settle anywhere in Palestine in respect of any land that has not been otherwise appropriated legally. Now, the West Bank was appropriated by Jordan in 1948 illegally. That was an aggressive war in 1948. It had no rights to go in there. If there were to be any rights in the West Bank, that should have been done by a Palestinian state. But the Palestinians did not establish a state. Jordan had no right. Jordan went in. Jordan purported to annex that territory. But that territory was, the annexation was never recognized except by two states, Britain and Pakistan. So the annexation by Jordan did not bring sovereignty to Jordan of that territory. And my argument is that if you do not have sovereignty, you cannot apply international treaties to territory over which you have no jurisdiction. You have control. Jordan certainly had control. It did not have jurisdiction to exercise civil authority over the occupied territory of the West Bank. Consequently, when Jordan signed up to the Geneva Convention, it had no authority to apply the Geneva Convention to that territory. But even that aside, I'm now going to go to Article 80, and it says, except as they agreed upon trustee agreements, placing territory under trustee jurisdiction, until such agreements have been concluded, nothing in this chapter shall alter the rights of any state or any peoples, or the terms of international instrument. International instrument means the Palestine Mandate. The people in the Palestine Mandate are only the Jewish people. The Jewish people, provided they do not detract from the civil rights of the then existing non-Jewish communities. Not future communities, not Arab communities, but religious communities who then existed at that time. Now, what are the rights of the Jewish people at that stage under the mandate? To settle anywhere in the West Bank and to acquire land, the land, not just public and wastelands, but the land. So my argument is that Israel has a perfect right to settle, a legal right. I don't say it has, I'll rephrase this, politically, it may not be advisable to exercise that right. We often have rights that we choose not to exercise because they like to cause political turmoil. And this is one instance, perhaps, where Israel ought not to exercise those rights to the fullest extent, but to restrain itself. And I think she has done in certain instances, and I don't want to get into the fence argument, but I'm happy to do so if anybody wants to argue with me. I'll be happy to send them my paper of 28 pages, which sets out the legal argument as to why the fence is legitimate and why the International Court of Justice made a very, very political decision and not on good legal terms. Next, please. That's it? Okay, I'm done.
No, 5 minutes. Wrap up.
Okay, there we go. You can read. Any questions?
Yes.
Written?
Sorry, yes.
The reason I ask for written questions is so that you don't make speeches. Oh, by the way, this talk, I did think about it. This is my United Nations tie.
Okay, sorry. Based on the interpretation of the Balfour Statement and upholding the religious rights of the non-Jews,
Non-Jews, yes.
you appear to be telling this audience that as far as Muslims are concerned, they have no rights at all. What about the indigenous Christians? Are they also excluded?
Absolutely not. They certainly do have rights. They do not have nationalistic rights. And that's the important thing. They have civil rights, which means the right to vote, they have the right to own property, they have the right to engage in business, unlike the Jews, by the way, who were prohibited by the Ottomans. Frequently, well, you have even in the Palestinian territories, the intention is no Jews are even allowed to enter, certainly in the case of Saudi Arabia. In the case of Palestine, certainly the non-Jewish communities have a right to exercise their religious freedoms, have a right to own property, have a right to engage in business, have a right to be members of parliament. They have all the civil rights, but they do not have rights, they do not have political rights in the sense of nationalistic rights. Yes, ma'am.
But my point was... that,
There's a second part to the
yeah,
question.
right.
I mean, and are they also excluded? What about Palestinian Arabs who have historical ties to the same men and may have been part of the original communities? What are their rights under the Balfour?
They have rights to be in Israel. However, we found out that if they decide that they cannot live under Jewish rule, and I just want to make a little point about this. The difficulty with Islamists is that Islam cannot tolerate the existence of a Jewish sovereign state which has jurisdiction over Islamists. The Islamists have a right to be there. Islamists have a right to be in parliament. Islamists have a right to work and to live and to marry and to procreate.
And to worship.
And worship, absolutely.
And to own property.
Absolutely.
So how, can I just ask, in that case legally, how you reconcile the idea that Jews are allowed to own property as part of Israel in that part of the West Bank, Palestinians living there are allowed to own property. How do you reconcile the desire for a group coming in wanting the same area that is already being inhabited by people already living there?
Distinguish between private rights and jurisdiction sovereignty. Sovereignty is a different thing, it's completely different. It has, sovereignty is the right to control and to regulate what happens there. Now, the fact that Israel, in exercising its power, even within Israel, recognizes minority rights. Well, don't do that to me, I've worked there. I know exactly the rights that Arabs or non-Jews are entitled and do in fact exercise. I have a judge at the Supreme Court who's an Islamist. In my own company, which I was the head of legal services, I had a number of Arabs there, and this was a very strategic company. It was the electric company. So Arabs are there. It's certainly in Israel, Palestinian, Israeli Arabs. They amount to 20% of the population, Israeli Arabs. Now, because some of them choose not to exercise their democratic rights to vote, and to exercise and to try to get some political leverage is a different
Can
question.
we talk about the West Bank? They don't have a right.
Well, sorry.
Sorry, Pat, do you want to write down a question only because I've got another question here we've been asked to read out. If you want to jot it down quickly, why ask this one quickly?
Sorry, it's just that you kept saying that they weren't entitled to political rights, that it was only civil and religion, and not political. And now
I'm saying the mandate says that the mandate does not grant non-Jewish communities a political basis, but they have civil rights. Well, I'm just looking at the mandate which is drafted by the British government. There's a clear distinction. You shake your head. It says clearly civil and religious rights, and it says they are obliged to provide a substructure or an infrastructure that will allow the Jewish political rights. Now, the purpose was very clear. There was a hope there would be established a Jewish, quote, commonwealth. And all the leading British parliamentarians agreed on that. At the time the mandate was created, the Jews were in a minority, and they could not be established as a state in the same way as Syria and Mesopotamia was. But they said there is a potential population which, if the Jews pull their fingers out and get going, and they want to invest, then ultimately they will have the right to set up a state in the West Bank, in the whole of the West Bank.
So what about the land of people who live there?
Well, wait a minute. You have to distinguish between my private right. I have a right to own land here in the United Kingdom, but I don't necessarily have the right to topple the government.
No.
The same thing in Palestine, except,
I'm not
well,
arguing with that.
the Israelis are not taking Arab land. If you're saying, just a second, if you're going to tell me I'm entitled to take Arab land if it's a case of public necessity or in the case of military necessity.
So
Now,
it's creating a park, a necessity.
look, if you want to give me a specific instance, I will investigate it because I still have the contacts there. What you're saying to me that certain land is being taken, you say for national park,
Military areas.
military areas justified. Excuse me, okay. Why? Because that part of the area, well, you shut your hands. This is under I've had a military occupation here. This is required for security. Where do you think the whole fence started? Because of the terrorism. There's only the suicide
Are they
bombers.
not allowed to defend themselves?
Who? You talking about? Who?
Okay, I think we can leave that. We've got another written question, and this gentleman's patiently waiting. How does your viewpoint compare with the Levy report in 2012 dealing with the same subject?
It doesn't. It's consistent.
Could you repeat that?
Sorry, the question is, how does your viewpoint compare with the 2012 Levy report dealing with the same subject?
It's consistent. And the reason is because this argument that I put forward under Article 80 has been I've been putting it forth for the last 8 years, and a person whose name is forgetting has just died, has written a very, very large book on it, Howard Grigg. And I think Baker and a few others managed eventually to get to the book and read it and say, oh yes, a very good argument, we agree with it. So what I'm saying to you is consistent with the Levy report.
Is there any other questions? Any other written points?
I would just like to respond to this lady here. I think you have to distinguish between the control of land for military purposes, which you may not agree with, and I'm not let into the secrets, but I don't always know what the military justification is, but there's a very interesting book dealing with the geography, the mapping and the geography of land from the perspective of military defense. And things that you would not think of can be justified for reasons of defense. Now, the fact that that the West Bank has been the source of terror, and that you cannot deny at all. The suicide bombers have been coming in. I've got enough statistics, believe me, up to my arm. Every month, I know how many people and how many attacks have been thwarted and how many people have been killed and the rest of it. And there's a state, certainly in Gaza, there's a state of war or a state of armed conflict, which incidentally allows me to use Article 51 of the United Nations Charter, because I'm entitled to inherent defense against armed attack. And there certainly is armed attack in the shape of the rockets coming over.
What about the defence of people who feel that their land is being unfairly occupied?
They have a right to appeal, and in fact, there's something I did mention, they can go to the High Court of Justice in Israel and believe all
To the occupied?
Pardon? Yeah. No, I want to tell you something. Unlike any other war, there's never been a situation where the occupied population, or the population under occupation, has been permitted to have access to the Supreme Court or the victorious power. I can tell you the High Court of Justice in Israel, it's called a Bagatz, is inundated with applications from Palestinians alleging the improper use of force or the improper acquisition of land by the Israel Defense Forces. And I have seen with my own eyes, sitting in court, when the court has said to the representatives of the state, well, why is the line there, why not there? And explanations are given in military terms, and then I was tossed out, because the rest I wasn't allowed to hear. Yes?
You'll take a question. Thanks very much. Can we move it forward a little bit now to the time when we're now talking about peace and possibility of establishing another independent Arab state on the, what I call liberated parts of Judea and Samaria. My question is, I know that Israel is helping the Palestinian Authority at the moment to actually reach that stage of that when they'll be ready for sovereignty. I know that they are helping them. But when they reach sovereignty, my deep concern is, will the same thing happen as happened in Gaza, that the Palestinian Authority, having established the state, would then simply topple, and they'll find their own members of parliament being taught flying lessons like they were in Gaza when it was chucked off the roof of their own headquarters.
You're touching a completely different area, which is a lecture that I give on Arab culture and Arab social structure.
Oh, sorry, I'll take it back.
No, the problem is that Arab structure is tribal. And the tribes work on the principle that the leader who emerges as a leader emerges as a result of internal conflict. And consequently, he's constantly having to fight off competitors. Therefore, he has to retain his position by showing that he's the most powerful, and his honor, his personal honor is at stake. And we've seen in the case of Bashar's father, who was offered virtually the whole of the land back, and he says, until I can put my feet back in the Lake of Galilee, my honor is not returned. And this is one of the problems. We're dealing with people whose norms are very, very different to Western norms. That may be changing. In the Arab Spring, we're going to find a lot of urban unemployed who are going to start looking at government from a different perspective. But whether the tribal underpinnings of that society are going to be destroyed, I don't know. But right now, it is still tribal, and you still look to the family, and you still look to the clan for protection and for advancement. And that's why in the West Bank, you're not going to have a government. What somebody has suggested, and I think it's interesting, is that Ramallah and Jenin and the other major Arab cities should be made into emirates, because essentially each one of these towns or these cities are controlled by 2 or 3 families, just as the emirates in Saudi Arabia, in the Arabian Peninsula. Make them emirates, and they do control their own internal government. It's difficult because for an Islamist to accept as having sovereignty, Jews who are dhimmis, that is second-rate people, or even Christians, is unacceptable for one reason. It displaces the supremacy of Islam, which is a basic plank of Islamic belief. To have a Jewish sovereign is anathema. Jews, they're dhimmis. To have jurisdiction, we should be subject to them? No way.
Got two more written questions, and they both relate to each other, so perhaps I can read them at the same time.
Yeah.
If the civil rights of non-Jewish communities within Israel or the West Bank are violated, is that a concern of the UN? And the other one in relation is you have not mentioned human rights. Where do they come in? Right. Human rights would lead to more security on both sides.
Good. The first one again?
The first one, if the civil rights of the non-Jewish communities within Israel or the West Bank are violated, is that a concern of the UN?
No. The UN's concern is not to interfere in the internal arrangements of a state. Now, so long as the territory of the West Bank does not become under Israeli sovereignty, I suppose the UN does have some concern, because if, as I've claimed, the Palestine mandate still applies to the unappropriated lands which form the West Bank, then there may be a case for the United Nations to be concerned about civil rights. That's the first thing. The second thing was...
You've not mentioned human rights. Where do they
right.
come in?
Human rights. We have a big problem here. Human rights are not absolute. I was looking at this afternoon. Human rights essentially is a relationship between the sovereign of the state and its own citizens. And that when a state subscribes to the human rights charters, economic and social rights and political rights, that is an agreement, a mutual agreement among states that they will treat their respective citizens in a particular fashion. It has never been suggested that a state has to control or has to be responsible for the human and civil rights of persons outside of its jurisdiction. Now, in the case of the fence, the International Court of Justice said that the human rights covenants apply outside the jurisdiction of Israel because Israel controls or has control over its own officers. The IDF and its agencies are subject to Israeli law, and since Israel has agreed to, has written or signed up to the human rights covenants, therefore there is responsibility, and the human right to take the human rights that protect property should apply. In the case of the fence, Israel claims that the human rights are not absolute, and they have to be subject to the question of security. Now, the International Court of Justice did not go into the factual situation of security. If you look at that opinion, they rely upon the statements made by the Secretary General, and they never got any factual evidence, as the Israeli Supreme Court has done, on the number of attacks, the extent of those attacks, and the military risks involved in leaving land unprotected or without a fence, or indeed in expropriating land. One of the most difficult areas there are two towns where there's a Supreme Court decision. One town, one settlement, the court said this was not expropriated for purposes, for military purposes, but for political purposes, and it was struck down. El Moed was a settlement that was established by the Israelis, and it was claimed to be essentially on Palestinian open ground, and the court struck it down because it said this was expropriated for non-military purposes. There's another case just on the other side of the hill which overlooked this area. The court said that was legitimate because it had a strategic location.
Okay, I think this is going to have to be the last question, I'm afraid. The Geneva Convention is usually cited as the basis for the illegality of the settlement. What are the flaws of this reason?
Well, I can't answer that now. 49.6. Look, the Geneva Convention, like all conventions, presupposes mutuality. I, as an Israeli, have an obligation to apply the Geneva Convention on the understanding that the opposing people also apply the Geneva Convention. The opposing people, being the Palestinians, have to be a state. You cannot, a non-state cannot apply the Geneva Convention for one reason. If I am a signatory, I have obligations, not just rights. Everybody talks about, where are my rights today? I keep saying, well, where are my obligations? And the obligation of a signatory to the Geneva Convention is to take action against those persons who are in breach of the Geneva Convention, namely who commit war crimes. Now, the Palestinians have committed war crimes. They directly shell Israeli civilian positions. And in those terms, there is an intention to maim, an intention to kill civilians. It constitutes a war crime. But I cannot demand that the Palestinians take them out because there is no government that is willing to say, I'm a state and I'm taking action. The Geneva Convention presupposes mutuality, and this is an area which is not a state. If it does become a state, and indeed, if I want to claim that, then I'm going to ask the simple question of why, if the Palestinians set up its interim government in the West Bank under Oslo, why has it not complied with its obligation under Oslo, like incitement, like the cessation of violence? I mean, I can go through a whole slew of things where there's breaches, and I don't know why Israel hasn't said, you know, this is ridiculous.
What about Sharon? He was criticised by his own government. He became Prime Minister.
Listen, you take Sharon out of one small thing. Sabra and Shatila, Sharon was the Minister of Defense and was held by an Israeli institution, not a foreign, an Israeli institution, to have been indirectly responsible for not anticipating that the phalangists would go in and would kill.
He knew very well.
You win.
Sorry, I think actually we're going to have to bring it to a close there. As I'm conscious we're 5 minutes over time, which Dr. Adler's got to catch a train. So Dr. Adler's very kind